Hi, everyone. Thank you for joining us over your lunch hour today for another one of our WESC webinars. My name is Lola Adebogan, and I am WESC Marketing and Admin Assistant. Our topic today is employee or independent contractor, why it matters. This is the last topic in our top 5 legal matters for entrepreneurs to consider series. Thank you all for being a part of this series, and we truly hope that this has been beneficial to you. Today's webinar will be presented by Kim Osmolak, who is an associate at W Law LLP. If you have any questions for Kim as we go through the presentation, please feel free to submit them in the Q&A box, not the regular chat box. However, do feel free to use the regular chat box to introduce yourself and tell us a bit about your business. And as always, this webinar is being recorded and will be available for on-demand viewing. You'll receive an email tomorrow at this time with the link to the recording. With that, I'll pass it over to Kim to now begin the presentation.
Good morning. I just want to make sure that you can all hear me and you see my slideshow. Everything looks good? All right. So good afternoon. Thank you everyone for attending today. Like they said, my name is Kim Osmolak and I'm an associate lawyer at W Law. Today, I'm excited to present on employment matters, specifically the difference between employees and independent contractors and the impact that this characterization may have on your business. This is the final webinar in the Top 5 Legal Matters for Entrepreneurs series. Previous presentations include topics on partnerships and shareholder agreements, how to protect your business name, and advice on dealing with creditors. If you haven't previously viewed those webinars, I encourage you to do so. As I mentioned, I'm an associate with W Law. W Law is a Saskatchewan law firm with offices in Saskatoon, Warman, Martensville, Outlook, and Melfort. We have 16 lawyers and handle a wide variety of legal matters. My practice focuses on corporate and commercial work, employment law, and general civil litigation. I work with many small businesses, structuring agreements such as employment contracts, purchase and sale agreements, and contracts with third parties. I also handle employment disputes from advising on potential terminations to carrying out court actions. Today's presentation will review the differences between an employee and an independent contractor. I'll guide you through the factors that differentiate the relationships, how the characterization of the relationship affects an employer in a wide variety of matters, including the advantages and disadvantages of each relationship. Lastly, I'll offer some practical advice that employers can use to limit their business risk when hiring workers and in ongoing business operations. In order to differentiate between the two relationships, it's helpful to review the nature of an employment relationship, the various ways it differs from other contractual arrangements, and the policy reasons behind the unique treatment of these agreements. And when I speak about employment relationships, just note that this doesn't include unionized employees, as unionized labor is governed by a different set of legal principles and legislation. At its heart, employment is a contract for services. It's an agreement where one party supplies services in exchange for a benefit from the other party. This is similar to other commercial agreements like your Netflix subscription or the lease on a car. Something is being provided by one party, such as the use of a car, in exchange for a benefit, like monetary payments. But employment agreements differ from commercial contracts in significant ways. Firstly, they're bound to comply with legislative requirements. The government has enacted laws that offer special benefits and protections to employees. This is what we commonly refer to as employment standards. In Saskatchewan, these are found in the Saskatchewan Employment Act and include such provisions as minimum wage, vacation entitlements, protected leaves of absence, and termination pay requirements. Certain categories of employment, like chartered banks and inter-provincial transportation companies, are regulated by the federal government, and similar protections are found in the Federal Canada Labour Code. Employment standards are the floor on which each employment agreement must be built. There's no ability to contract out of employment legislation laws. And this is unique to most commercial agreements, where the parties can negotiate the terms freely without legislative intervention. Employment agreements are also unique from other commercial agreements in how they're interpreted by the courts. In a dispute over a written commercial agreement, the courts generally only consider the terms that are expressly set out in the written agreement. It's uncommon for the courts to find that parties agreed to additional terms that weren't captured in writing. Essentially, in a normal commercial agreement, the parties are stuck with what they had written down. The law takes a much more flexible approach to employment agreements. Courts are more willing to find that parties had agreed on certain terms, although those terms were never expressly documented. As such, employment agreements can be made up of written terms, oral terms, terms implied by the law, and terms implied by the conduct of the parties, or a combination of these. And this makes sense. It's not unusual for an employee to be hired without more than the position and the wage being written down. Employment is also fluid, with the reasonable expectations between employer and employee changing as the relationship develops. For example, there's a case where an employee had accepted reasonable location transfers in the past throughout his employment. When a dispute arose, the court found that an obligation to accept reasonable transfers was implied in the employment contract because of the past conduct of the parties. An employment agreement can begin even before the employee starts work. There's cases where an employment relationship was found to have been formed, even where the prospective employer and candidates were not of the same understanding. The conduct of the employer led the candidate to believe that he had secured employment. Since the candidate's understanding was reasonable, given the employer's conduct, an employment relationship was found by the courts. One of the most significant terms that the courts will imply into an employment agreement is the requirement for reasonable notice of termination of the agreement. This can lead to significant damages for an employer that fails to provide notice to an employee. We'll explore this ground of liability further when we get into our wrongful dismissal discussion. Another unique aspect of employment agreements is that the court will always refuse to make the parties carry out the agreement. While the courts may sometimes order that a contract must be carried out, usually like forcing the sale of a unique property after the seller backs out of a sale agreement, instead, the courts will never require that an employee go back to work and fulfill the agreement, or that an employer take the employee back into their employment. There's good reasons that these protections that you don't see in other contracts are imposed on employment agreements. The special treatment stems from the vulnerability of employees. The important role that employment plays in a person's life, the fluid characteristics of employment, which require a flexible approach in interpretation. Here on the slide, I've included a quote from the Supreme Court of Canada regarding the central nature that employment plays in a person's self-identity. When dealing with employment disputes, these principles are always in the background. Now let's move on to the independent contractor relationship. An independent contractor is said to be one who contracts for service rather than of service. Typically, an independent contractor is referred to as somebody self-employed or as being in business for him or herself. Determination of whether a worker is an employee or independent contractor will depend on the conduct of the parties rather than the label that gets applied to the relationship. So self-employment, it won't be found just because you structure the agreement as saying contract agreement or consulting agreement. It also won't be found just because you've named the title as something like independent contractor or a consultant. Self-employment status on a tax return also alone isn't sufficient to establish an independent contractor relationship. And just because the length of the relationship is short and for maybe one distinct purpose, that doesn't also make it that it's an independent contractor relationship without further factors. So there are cases where, although a worker filed his tax return as being self-employed, the court still found that the worker was an employee. This case was a compensation on behalf of the deceased diver by his widow. It was a claim for workers' compensation. The issue was whether the deceased diver was an employee and therefore his widow qualified for workers' compensation benefits. The owner of the diving company who hired the diver indicated the time, the place, and the method of how the dive was to be done. The owner provided the equipment and paid hourly wages. These factors established the owner as an employer and the diver as employee, notwithstanding that taxes had been filed by the diver as self-employed. And like I mentioned, employment isn't limited to ongoing relationships either. Employment relationships have been found to exist even for a single transaction. For example, an employment relationship was found where one neighbor had volunteered to help the other neighbor combine his crops for a day. The courts have developed different tests for how to determine whether a worker is an independent contractor. These tests set out the indicators that should be considered. Many tests have been developed with certain factors listed as something specific to consider. But each of these factors comes back to how much control a worker has over how the work is done. So as we go through these tests, don't get caught up on the details of, okay, which factors do I have to consider? Just remember, when looking at the relationship, it all comes back to how much control does the worker have over how the work is done. All the other factors are just ways to assess that level of control. Simply being paid by piecework doesn't necessarily indicate that the worker has a chance to make a profit, as is stated as one of the tests, the entrepreneur tests. And owning tools is an indicator of being an entrepreneur, but mere ownership of some tools doesn't automatically render a worker an independent contractor. The size and the nature of the tools provided may be relevant in determining the existence of an employment relationship. The fact that the worker did the work on the premises of the alleged employer isn't determinative of the relationship either. One solid indicator that isn't expressly laid out in this entrepreneur test is whether the worker has the authority to delegate the services performed. So hiring people under him to do the work or assigning the work to another party. Without this power, it's quite a bit likely that the court will find that the worker is an employee. So the analysis, it can be quite complicated with the different factors to consider and how some factors are present and others aren't. In one employment standards case, where they applied this entrepreneur test, an individual was found to be an employee even though he operated a store for another, fixed his own hours of work, engaged and discharged his own employees, ran the risk of loss, and was not supervised in the manner of carrying out his work duties. An employment relationship was still found because he was expected to devote all his time and all his attention to the employer's store, to the exclusion of any other business or occupation. He was only allowed to sell items at prescribed prices. He had to pay over all the proceeds and keep the store open during set business hours. As a result, the court found that the worker was managing and operating the business on the employer's behalf. The business was not his own. The organizational test is another test created by the courts. The Supreme Court of Canada has adopted it as an enlargement of the earlier entrepreneur test. It essentially provides that a worker is an employee where his work is done as an integral part of the business, whereas although an independent contractor does work for a business, that work is not integrated into the business but is only an accessory to it. Of course, many other tests and factors have been laid out in subsequent court decisions. Again, I remind you that the guiding principle is that no factor is conclusive. You have to look at the whole of the relationship. And behind all these different factors that the courts consider is the notion of control. They're all a means of examining the level of control that a worker has over his services or her services. The characterization of a worker will affect a business in multiple ways. This includes whether the employer must adhere to the provisions of workplace standards legislation, whether the worker must pay severance upon the termination of the relationship, whether the employer must deduct income taxes, employment insurance, and Canada Pension Plan contributions, whether the employer could be liable to third parties for the conduct of the worker, and whether the worker may be included in a union bargaining unit. A worker characterized as an independent contractor, but who is in fact found to be an employee, can claim lost wages and other entitlements granted to employees under the Saskatchewan Employment Act. So the employer could be on the hook for paying less than minimum wage, or they could have to pay over additional funds to make up the shortfall between what was paid and what minimum wage would be. They might be on the hook for having to pay additional funds for overtime, holiday pay, or termination pay. Also keep in mind that unpaid wages are one of the liabilities that a director of an employer corporation could be personally liable to pay. This liability can be up to 6 months' wages as long as the services of the employee were performed while that particular director was on the board. This liability would also include any severance pay that the employee is either entitled to under the employment standards legislation or found by a court to be entitled to under the notion of reasonable notice. One of the biggest risks in mischaracterizing a worker as an independent contractor when they are in fact an employee is having to pay damages in lieu of reasonable notice of the termination of the employment. The failure to provide reasonable notice of termination is referred to as wrongful dismissal. Wrongful dismissal isn't concerned with the wrongness or rightness of the dismissal itself. The law entitles both employers and employees to terminate an employment relationship without cause. A wrong in wrongful dismissal only arises if the employer fails to give the dismissed employee reasonable notice of the termination of the agreement. The remedy, which is called damages, are based on the period of notice that should have been given. And that length of notice period is based on the time reasonably required for the employee to find similar employment. The damages represent what the employee would have earned during that time where they should have been working but given notice that the termination was coming up. A carefully drafted employment agreement may limit the applicable notice period to the minimum set out in the Employment Act. The Employment Act provides for 8 weeks' wages upon termination, where otherwise, if termination pay isn't spoken to in the employment agreement, or where termination terms aren't sufficient to displace the common law notion of reasonable notice, then the applicable notice period under case law could be as high as 2 years of wages. So if a worker previously treated as an independent contractor was successful in claiming that they were in fact an employee based on all the factors in their employment, the employer would be liable for paying damages for lack of notice under the common law reasonable notice standard, which again is up to 24 months. If the employer had actually treated the worker as an employee, they could have limited the notice payable in the employment contract, or at least have known to provide working notice. Wrongful dismissal is another consideration where you have what's called dependent contractors. A dependent contractor is essentially an independent contractor who has control of their business, but who is nearly completely reliant on a certain business for their work. So they only do work for a certain employer. That employer makes up the whole of their operations. So even though this employee acts independently and for all the factors that we've talked about would qualify as an independent contractor, an employer may still be required to give that dependent contractor reasonable notice that the agreement is coming to an end. On the other hand, these dependent contractors, the employer won't have to take their source deductions for income tax. They won't be liable for the actions of the dependent contractors. They don't have to give the dependent contractors the benefits of the employment standards legislation. It's only under wrongful dismissal considerations where you're going to look at the distinction between independent contractors, dependent contractors, and employees. A mischaracterization can also have tax liability consequences. An employer is required to deduct the employee's portion of his or her Canada Pension Plan contributions employment insurance premium, and applicable income tax. If an employer fails to deduct CPP and EI, they're responsible for these amounts, even if they can't subsequently collect them from the employee. This includes both the employee's share and the employer's share. In addition, CRA can also assess penalties for failure to deduct or remit these amounts. And this is another debt that a director of a corporation could be personally liable for if they were a director at the times that this income was earned and the failure to pay those source deductions had occurred. When treating a worker as an independent contractor, the employer would not deal with any source deductions. So this creates the risk that later, if the employee represents to CRA, if the worker represents to CRA that they were in fact an employee, the employer could be on the hook for those CPP, EI, and income tax payments. Luckily, the test for determining whether a worker is an independent contractor for tax cases is a lot more lenient. The first thing that CRA would look at was the intention of the employer and the worker. If there's evidence that the intention was to have an independent contractor relationship, then CRA only has to find some factual evidence in the relationship that supports the independent contractor relationship. Essentially, CRA doesn't look at the whole circumstances of the relationship to determine how the worker is characterized. Instead, they look at the parties' intentions, which could be demonstrated in a written agreement that says independent contractor agreement, or the title given to the worker, which is consultant. Those are the main factors considered by CRA. And then there only needs to be one factor in the actual working relationship that supports this conclusion of independent contractor, rather than CRA looking at the preponderance of factors, not considering intention, and coming up with a characterization that way. So essentially, an employer has more control over their liability for tax purposes. Whether a worker is an employee or independent contractor will also determine whether the employer could be responsible for wrongs committed by that worker. Being responsible for wrongs that were committed by someone else is referred to by the courts as vicarious liability. An employer is vicariously liable for the wrongful conduct of its employee, where such conduct can be considered a mode of fulfilling an actual act authorized by the employer. Even when the employee's impugned conduct constitutes an improper or unauthorized mode of performing the work, the employer will be held vicariously liable. The mere fact that an employee commits a criminal or illegal act is not in itself enough to have the conduct taken out of the scope of his or her employment. In one case, the employer was liable where a postal worker stole a package during the course of his employment. Some other examples where vicarious liability has arisen are where an employee negligently left a delivery truck unlocked and where subsequently parcels were stolen. A conductor who, while collecting a passenger's ticket, assaulted the passenger. A driver or a taxi driver negligently allowing a drunk off-duty colleague to drive his cab, where an employee was involved in an accident while driving his own car immediately after calling at a house to make a collection, which was part of his job. He was found to be acting in the course of employment. A journey to obtain a meal away from a work site during a meal break has also held to be considered part of the course of employment, since it's fairly incidental to the work instruction actually being completed. The willingness of the courts to hold an employer responsible for the actions of employees comes down to the control principle that we talked about earlier. Since an employer has at least some control over the employees and over the business generally, the employer is the one creating the risk for the public. And because they're creating the risk, they should be responsible for the consequences of that risk. Think about a construction company. The company is the one that causes their employees to drive between different construction sites. The employer ultimately gains from this work being carried out. If the employee were to run someone over with their vehicle, the employer should still garner some responsibility for creating the circumstances where a potential injury could occur in the first place, even though it's unlikely. The last consideration, even though it's not so much a liability on the part of an employer, but something to keep in mind is that only employees can be part of a union bargaining unit. It's a growing trend in employment law that workers of the gig economy, so people like Uber drivers or meal delivery drivers, they are attempting to be considered employees and unionizing in an effort to combat the way that companies are using this independent contractor status to limit how much they need to pay these workers while retaining a larger portion of the profit. A meal delivery courier service, the workers in that work actually recently were successful in being held as employees, and they unionized, and unfortunately the business took its operations out of Canada after that happened. So gig economy workers do have a big uphill battle in combating the kind of exploitation that is happening in those types of working relationships, which is quite disappointing, but just something to point out. So as we've discussed, characterizing a worker as an independent contractor has several advantages for businesses. They're not required to adhere to employment standards regulations that could minimize the amounts payable to the worker, as the employer would not be responsible for holiday pay or other benefits. Essentially, it keeps the cost down for employers. Unless something is included in the contract to that effect, employers don't have to pay anything on termination of the agreements. They don't have to pay into the employer share of the worker's CPP account, and they can avoid the hassle of source deduction, management, the collection, and the remittance. They generally can't be sued by third parties for wrongful acts of the worker, and the inability to unionize can also keep labor costs low for the employer as well. But beneficial as it is to hire an independent contractor, doing so when the facts don't actually support that kind of relationship, that creates risk. The risk can arise both through unseen and therefore unplanned liabilities, and also by missing the opportunity to limit risks in a properly drafted employment agreement. An employer should assess the individual's intended duties and responsibilities, the nature of the relationship, especially the degree of control the employer intends to exercise over the individual, in order to evaluate whether the individual will truly be acting as an independent contractor or whether in reality it would be an employment relationship. When considering hiring someone as an independent contractor, and there's any hints of uncertainty whether this relationship would be actually considered an independent contractor, talk to a lawyer. Just call me and we can work through it and make sure that there's no mistake in the characterization. When hiring an independent contractor, the employer should also limit controlling the work. It's fine to say what must be done and when it must be done by, but the more control the employer has over the how, the more it pushes the relationship towards employment. It's also important to have a well-drafted agreement that reflects the parties' intentions. Even with an employment agreement, the courts are always looking for ways to poke holes in it because they want to confer the most benefits to the employees that they can. That goes back to those policy considerations that we talked about earlier, how employees are vulnerable. So the courts do whatever they can within the context of an employment agreement to give them the most benefits possible. So if you are doing an employment agreement, it's a really good idea to have a lawyer review it, because in order to oust those implied terms, the language has to be very clear and very specific. So feel free to reach out to me and run the agreement by me, and I can make sure that you have all the important protections in place and that those protections are defensible in court. It's also important to get legal advice when you're considering firing an employee, especially a long-term employee, or where there might be human rights concerns in play. So if you have an employee that has a disability, or an employee that's off for sick leave or off on mat leave, and you're considering terminating the relationship, it's a really good idea to have a lawyer look at the situation. So I can help you determine what an appropriate severance amount might be that would limit the potential for an employee to make a wrongful dismissal claim, whether the employee's conduct would give rise to cause for dismissal, in which case the employer wouldn't have to pay severance, and many other concerns and strategies for dealing with the termination of an employee. That's everything I wanted to talk about today. We have lots of time for questions, and I see that there's a few in the Q&A, so I'll get to addressing those. First question: if an independent contractor works for companies in multiple provinces, but only one company in Saskatchewan, is there anything that would indicate this is an employee condition rather to the independent contractor? Right. So again, you would look at the work that that independent contractor is doing for that employer. So if you've hired somebody as an independent contractor, they're also doing work in other provinces. If you're still controlling how they do the work for you, then there could be an implication that they are your employee, notwithstanding that with other relationships, they're an independent contractor. Perhaps in those relationships, the person hiring them doesn't have as much control. But it's a good point you bring up that where the same company is doing work for other people, it looks a lot less like an employment relationship because they have other things going on. They don't have to devote their full time to one employer. So I would say you do have to look at the whole situation, look at the amount of control that's being exercised over this independent contractor, but likely it wouldn't be an employment relationship. Of course, if you have any questions about this in a specific context, do reach out to a lawyer. All right, the next one: do non-compete agreements play a part in the analysis of employee versus independent contractor? That's a really good point. It does. So that's one of the overall factors considered. So if you have this worker and you get them to do a specific job for you, and then you say, you can't do this job for anybody else, then you're exercising a lot of control on what this worker can do. And so that would really point heavily towards an employment relationship. Now, what you can do is say, hey, while you're working for me, you can work for other people at the same time, but you can't work for people where it would create a conflict of interest, or it wouldn't allow you to get the work that we need you to do done. So implications on, or directions on what they can do while they're working for you, as long as they can work for other people. Then that points towards an independent contractor relationship, where you try to regulate the behavior after the relationship. That would point towards employment. Now, with confidentiality, that's a different beast. It's completely acceptable to contract with an independent contractor and say that they can't use any confidential information that they obtained working for you in other contexts. That's reasonable with both employees and independent contractors and wouldn't factor into the analysis. What if the contractor wishes to retain that status, even if the criteria you provide indicate that they really should be an employee? I would first run that by a lawyer to make sure that you're analyzing the criteria properly. And if it's still the case that this employee should really be, this worker should really be an employee, then you would want in your agreement strong language about what must be paid on termination to limit your damages. This is what you do for an employee anyway. If the agreement is specific about you both agreeing this is an independent contractor, then that's fine for tax purposes. You'll be okay not deducting CPP and not paying your share. Where it becomes kind of an issue is employment standards. So this employee could, at the end of the relationship, make a complaint to employment standards and say, hey, I was really working as an employee and they didn't give me overtime pay, minimum wage, things like that. So that is a risk. And you really have to assess, how likely is that worker to be successful in making that claim and proving that they're an employee, and how likely is it that they're even going to bring that claim, right? It's like, what's at stake here? So you have to look not only at what the law would say, but in practice, what works for your business? What level of risk are you willing to deal with? So the next question is, if I want to have a person casually run nature walks, outdoor activities, would I pay them as an employee on a casual basis or pay them as a contractor? Again, you'd have to go into more factors. I don't want to say for certain one way or the other because I can't give legal advice to specific situations without getting a retainer for insurance purposes. So I can't answer this one specifically without talking to this person further. So feel free to reach out to me for a quick consultation. But really what it comes back to is, okay, are you just saying you need to give this service on these dates, but how you give the service, what types of things you say on this nature walk, how many you want to do a year, which ones you want to do. If there's a lot of control for the worker, then you might want to hire them as an independent contractor. But if you're exercising a lot of control about when they're doing the walks, how long the walks are, what they're saying on the walks, then it might be an employee situation. The fact that a worker is a casual worker, it doesn't factor one way or the other on that analysis of independent contractor or employee. Like I said, there's been cases where somebody only worked for a day and had been considered an employee. So don't rely on just the fact that somebody's a casual worker. Okay, so the next question is somebody who owns a day spa, they've got extra room in their business, they rent it out. This person that rents it is in control of hours, payment, bookings. They pay a fee to use the space. Should we, I think, consider, if this is an employee? So again, I can't answer specific legal questions without a retainer. What I can say is that, again, look at the level of control. Indicators of self-employment are that the person can control their hours, can control what work they do, when they do the work, how they do the work, and paying a fee to use a space that also favors towards self-employment. So again, specific legal advice I can't answer, but I can tell you that those are the indicia of self-employment. And if you want to be sure and have your particular circumstances reviewed, don't hesitate to give me a call. How do we contact you and what are your fees? So all my information is on the W Law website, just wlaw.com. It'll have my email address and phone number. Shoot me an email or give me a call. I usually do consultations up to half an hour. The initial consultation is complimentary. And then after that, we just open a general file. And anytime you have a question, I can deal with it. We'll build the general file. My hourly fee is $2.50, and then that's separated into 6-minute increments. So if we only talk for 6 minutes, then I only bill you for 1/10 of the time. All right, so the next question. In the same situation, it is a 1-year signed contract. If I decide to not renew the contract, I give 2 weeks prior to the contract end date to notify them of the contract being renewed. Is that enough notice? I'm sorry, I don't remember what this specific situation was, if it's the renting the spa. But again, I'd have to look at the contract and I'd have to get more information about the circumstances. So unfortunately, this isn't one that I can answer live right now. But again, I encourage you to reach out. All right, the next question. Is there a restriction on the amount of time, number of years, that a person can work for a company as an independent contractor? No, there is no specific timeline that after X number of years, they're now an employee. Where that is considered is in the dependent contractor analysis, where if they're an independent contractor, but they only work for you and your business, and they've been doing that for several months to several years, then you might have to give them payments upon terminating the contract or notice of that. But it isn't just the passage of time that would make an independent contractor into a dependent contractor. It's also those other factors about whether they do work for other people, how much work do they do for you, those kind of factors. So again, the passage of time itself doesn't indicate one way or another. Okay, I'll give a couple minutes for any more questions. Make sure you put them in the Q&A box and not the chat. We do have a few more minutes, so I'll give it just maybe 1 more minute. Can you recommend a good source of information for hiring casual workers versus contractors in Saskatchewan and payroll? If you go to CRA's website, they do have some resources for how CRA would characterize somebody as an independent contractor versus an employee. So you can actually look at their resources. They'll offer more details about, specific situations. Sometimes I believe they give an example of a realtor. So, okay, if a realtor is paying for space, makes these payments, does these things, then they're an employee. If a realtor is doing these things, then they're an independent contractor. So they'll give more specific examples that might be more helpful to your particular business. So I would look there. Okay, give it another minute for any more questions. What if you allow people to work for other companies, but they choose to not work for others, and only you as an independent contractor, do they still get put in that dependent contractor circumstance? That's a really good question. That's never been adjudicated but the opportunity to work for others would indicate that they are still an independent contractor. If they don't take advantage of that opportunity, then you probably won't be on the hook for giving them termination payments. It would be a very fact-specific analysis. You'd have to look at the terms of the contract, and you'd have to look at how much work is expected from this particular contractor. If the work is all encompassing, and even if they wanted to, they couldn't take on other work, that would favor more towards dependent contractor. But if it's maybe, a few jobs a month, or it's more kind of a 9 to 5 or less type work, and if they wanted to, they could take up other work, then likely an independent contractor situation. And one last thing I'd like to stress, not just about the difference between employees and independent contractors, but the importance of having a good employment contract. And you can't just draft one up and say, okay, existing employees, sign this, because you need to give them something in exchange for signing this new agreement. So you both need consideration, and you need to make sure the clauses are clear and they're going to be defensible. And the only way to guarantee this is really through a lawyer. It's a very specific practice, and most lawyers can look at your contracts and make any necessary changes for a very reasonable amount. So I'd encourage you to reach out. Another question. Would you please mention a source of information about hiring an employee or making contracts in Saskatchewan? There's information, I believe, PLEAS, that's Public Legal Education Association, might have some resources. So PLEA, you can just Google PLEAS Saskatchewan. Women entrepreneurs, I'm sure, would have some materials that you can reference about making contracts and hiring employees. Other business networks as well. I would look at the workplace standards websites in Saskatchewan. So if you just go Government of Saskatchewan, Employment Standards, there's some resources there. So hopefully those are helpful. Again, maybe I'm going to take a look and see what other resources I can provide, and maybe Wes can circulate that with the link to the slideshow. So if I do come across further resources, I'll send that to Wes. Okay, the next question, what is the cost for a basic employment agreement? That would really depend on how complicated the employment relationship is. If it's a small mom and pop shop, it would be a few $100s versus if you are a large operation with different types of employees, then that might be more expensive and you're looking at into the thousands of dollars. So what you can always do is email me, tell me your circumstances and ask for a quote. You can even send me what you already have and I can work off that, and that can reduce costs. So don't hesitate to ask for a quote with giving me your information, and we can work it out that way.
I think that that's all the questions. I'll wait for a little bit in case there's one more. Let me see. If not, thank you so much for that excellent presentation, Kim. It was very well informative, which is why we had so many questions. Thank you for being a part of our series. It's been such a beneficial series for entrepreneurs because everyone always seems to have legal questions. And thanks for all of you who took time out of your busy days to join us today. Don't forget to check our events page at west.ca/events to register for our upcoming webinars. Our next webinar is happening next Wednesday on February 3rd, and it's titled Introduction to Exporting. Our presenter will be Jeff Shraki, who is the Senior Director of Market Intelligence at STEP. It will be a very interesting presentation, and I hope to see all of you there. I will now end the presentation, but thank you all so much for joining again. Have a nice afternoon, everyone.
Thanks, everybody.
Bye.